Good evening. Today, in relation to environmental law, I propose to deal with chapters 3, 8 and 9, rather ambitiously, in relation to Bates environmental law. Chapter 3 deals with environmental protection and the common law. Chapter 8, strategic environmental planning. And Chapter 9, environmental assessment of projects and activities and development control. Commencing firstly with Chapter 3, environment protection and the common law, running from pages 57 to 95. In the introduction, Mr. Bates makes some comments, as we've discussed earlier, that environmental law is the product of legislation. It's not a creature of common law. There are 5 reasons for this. Firstly, to be effective, environmental legislation had to recognise and, if necessary, overcome common law rules. We talked about the common law having a predisposition to dealing with issues regarding property rights. Secondly, principles of common law underpin and protect fundamental social structures, such as respect for private property and individual rights of freedom. Thirdly, common law remedies are important, remedies such as declarations and injunctions, as well as damages. Fourthly, interpretation of statutes may depend on concepts developed at common law. And finally, where persons or property or their businesses are affected, then the only way to gain compensation for harm is to take common law action for damages. So environmental law, effectively brand new, coming on back of common law, which has been around for centuries and centuries. In dealing with the importance of property, Bates says that recognition of rights over property is fundamental to this capitalist social structure. Indeed, the legal fiction that was exposed in Mabo, that Australia was terra nullius at the time of invasion, was based largely on the absence in Aboriginal communities of any formal or delineated recognition of rights over property. Halfway down 58, at common law, proprietary rights of a landowner extend up to the sky and down to the centre of the earth. Those who have best possessory rights to land can also control access to and exploitation and management of resources on that land. The only restriction at common law is the presence of neighbouring landowners who have similar rights, and any restriction on their right to access and enjoy their property without interference must be respected. So environmental legislation imposed restrictions which cut across those common law rights. At 3.4, rights to develop land and exploit natural resources of land are now generally controlled by legislation, but the right to decide how to manage the land has until recently been largely unfettered. Over the page, at the bottom of page 60, Bates comments that the common law imposed no regime of management on private landowners. A landowner was free to exploit and degrade the resources on the land, so long as the use and enjoyment of neighbouring property was not unreasonably affected. So that phrase there really does encapsulate or provide the key for the genesis of environmental law. It was essentially, under the common law, before the introduction of legislative constraints, open slather. At 3.9, Bates makes reference to the creation of proprietary and permissive interests, saying that a landowner can create a variety of subordinate legal interests that allow others to enjoy access to or possession of land and natural resources. These interests may have the security of being a form of property, a proprietary interest, or simply be permissive in nature. Proprietary interests include leases, easements, covenants, and profits a prondere. Now, you're probably all familiar with what we mean by leases and easements. Covenants, maybe not so much. Profit a prondere is a right to enjoy the benefits of something which is from the land. Usually the right to extract timber, for example, is a profit a prondere. Now, 3.10, he says permissive rights or licenses don't have the security attached to them as a right in property, they can be revoked at any time, and though if coupled with a contract, revocation may trigger a claim for breach of that contract. So a license, for example, might be an entitlement to come on and use part of the land for a certain purpose for a certain period of time, but it doesn't necessarily carry with it the proprietary right of an easement. So just to explain the difference between the proprietary right of an easement and a mere license. If, for example, you owned real estate and you gave someone the right to access part of that real estate so that they could drive their car down the particular area of land in question to get to their own property, that would be a proprietary right which is vested in that other owner, which is in the form of an easement. If, however, you said to your neighbours, look, come in and use my swimming pool anytime you like, that's not a proprietary right that you've conferred upon the neighbour, it's simply a licence to come in and use that swimming pool. So I hope that provides some real example of the difference between a proprietary right and a licence. Now, just over the page, at page 64, he says, allocation of statutory rights to water and fisheries, for example, have traditionally been by way of licence. It's very difficult to plan for commercial operations if access to the resources that underpin investment can be taken away at any time, which is typically the case in a licence situation. So gradually, both regulators and regulated community began to treat the licences as de facto property entitlements, even though they weren't. The effect of environmental legislation on common law rights at 3.13, Bates says, courts often regard their role as standing between individual rights, usually well supported by common law, and excesses of bureaucratic power. The principles underlying judicial review are therefore accountability and transparency. Judicial review is something we'll deal with a little later, but it is effectively an application made to a court, asking the court to determine whether the appropriate procedures have been adopted as part of the decision-making process. That is something which is different to a merits appeal, where in making the application, the determining court or tribunal is asked to consider the matter on its merits. In other words, make the decision and not just determine whether the appropriate procedures have been adopted. So that's the difference between judicial review and a merits appeal. 3.14, while removal of long-standing principles of common law would not be undertaken lightly, modification or removal of common law rights may well be considered necessary to address contemporary environmental or social concerns. At 3.15, legislation may also deem it necessary to modify or abolish common law rules. In New South Wales, for example, common law rules about standing of a person to address courts have simply been abolished. There are no persons aggrieved in New South Wales. Any person has the right to take action to remedy or restrain breaches of environmental law. In chapter, I think, 19, or thereabouts, there's a discussion in relation to the principle of standing, which we call locus standi. So New South Wales has adopted, I think, a very progressive approach by saying that the environment affects everyone and anyone can come to court and lay claim to seek a remedy or restrain something that's happening in relation to environmental law. In other jurisdictions, Queensland included, you still need to establish that you have a right to be before the court. We call that standing or locus standi. At 3.15 on page 66, he says, another example is the doctrine of riparian rights at common law. Most jurisdictions have abolished this right only to replace it with a very similar but more detailed statutory entitlement. Thanks, Rodney. Now, at 3.17, there's an important point made. All environmental statutes will, to some extent, modify the common law rights of private landowners to conduct activities on the land that do not unreasonably interfere with neighbouring landowners. And that's, again, the key. So we've established that at common law, landowners have certain long-standing rights. They're effectively unfettered, provided they're not interfering with the neighbours. It was essentially, at common law, open slather. And legislation is the way in which environmental law has been established and enhanced in Australia, and it's all very recent. Over the page, on page 67, Bates says, environmental legislation not only frequently and deliberately preserves common law rights indirectly, but also may expressly preserve rights to take common law actions, providing specifically that civil rights and remedies are not to be limited by the provisions of the legislation. Common law remedies to compensate for damages caused by pollution emissions, for example, would be considered complementary to statutory schemes for managing pollution. And we'll deal with pollution later in, I think, one of the chapters 16 or 17 or thereabouts. Now, any questions at this stage? So please allow me to continue. I'll find out where I'm up to. Common law actions 3.18. The common law does not regard and has never regarded harm to the environment per se to be worthy of a remedy. The common law did have actions in nuisance that could compensate a landowner for damage to the environment, but that was because the common law viewed this as an infringement to the landowner's property rights rather than any breach of duty to protect the environment. Bates then goes on to talk about some of the typical common law remedies which law students learn about in the subject torts, T-O-R-T-S. The first is nuisance and trespass. A trespass is a direct intentional interference with land. A nuisance is an indirect interference with a person's land. A trespass theoretically is actionable without proof of harm, but in nuisance, actual damage must be proved. He then goes on to talk about nuisance, and at 3.22 gives an example. The pouring of heated water into a stream is an act of pollution, but in a legal sense, there's no liability unless the quality of the water also deteriorates sufficiently to cause harm. So therefore, pollution does not necessarily equate to nuisance. He then goes on to talk about public nuisance and other types of nuisances until we get to 3.29, which is negligence. And negligence is, if you like, the most important aspect of torts law. It's the most common and important common law action. At 3.29, whereas actions in trespass and nuisance remedies interferences with property rights, the action in negligence is generally used to take action for personal injury and economic loss. The basis of the tort of negligence is that all persons owe a duty of care to avoid harm to others who might reasonably be foreseen as likely to be affected if activities are carried out or not carried out negligently. And that all goes back to the basic rules of negligence, and that's at 3.30. At 3.31, loss or damage from negligent acts or omissions that cause environmental harm would generally be expected to take the form of financial loss or personal injury. He then refers to a case of Armidale City Council against Alex Finlayson, where the council was found to have been negligent in giving approval for a subdivision over land that later proved to be contaminated, and damages amounting to several $1 million were ultimately awarded by the High Court in that case. At 3.32, economic loss may also, of course, be caused by the negligence of neighbouring landowners, as well as the actions of bureaucrats. He then refers to a South Australian decision where a farmer successfully claimed damages from a neighbour whose negligent conduct had allowed his potato wilt to be spread onto his land. An environmental pollution example is Ryan against the Great Lakes, which is at 3.33. And in that case, there was a surge of reported hepatitis A viruses. An investigation attributed these cases to the consumption of oysters. He then goes on to say that council were aware of deficiencies in the sewage systems of the area surrounding the lake, and council had gone so far as to resolve that issues of effluent treatment should be addressed, but no concrete action was taken. So in that case, at first instance, Judge Wilcox concluded that all the respondents had been negligent and made an award of damages for compensation. Over the page at 3.36, assumption of control can be a critical issue in grounding liability for government authorities. And at 3.37, the question of control over threats arising from climate change, such as the vulnerability of beach owners or beachfront landowners, and resultant council works to protect against or rehabilitate damage, has also been postulated as one way in which actions in negligence might arise in climate change litigation. So councils, of course, are very, very concerned about potential future liability in negligence by allowing subdivisions to occur now in circumstances where rises in water levels may result in economic and other loss to landowners at the time. There are some defences. At 3.40, activities that would otherwise cause a nuisance at common law are more likely to be conducted in an area zoned by local government for that purpose, and the mere issue of a permit for development or a licence to emit pollution will not automatically provide a defence to an action at common law. This is because the issue of a licence is an act of executive, not parliamentary governance. Now, the example is Van Son against Forestry Commission of New South Wales from 1995. The Forestry Commission was held to be liable to a downstream landowner for siltation caused by logging. These activities had been licensed by the New South Wales EPA. And in that case, the Forestry Commission was logging under its own statutory authority. Bates makes the following observations. Legislation could, of course, because it's superior to the common law in cases of conflict, authorise the commission of common law nuisances and also negligence in carrying out those activities. Persons and public authorities are not immune from actions in nuisance and negligence simply because they're purporting to exercise public statutory functions. So just because you have a licence, just because you have authority to do something pursuant to a statutory authority, does not mean necessarily that you are immune from an action in damages arising from nuisance and or negligence. Parliaments have shown willingness, however, to exempt statutory authorities from the consequences of their own actions, usually so long as the activities complained of were done in good faith in pursuit of their statutory function. So even though various government authorities are not immune from action, they can be held to be exempt provided they acted in good faith. And that is, but the legislation which exempts the authority must be very clear in providing that exemption. Now at 3.42, the case referred to is Forbes Shire Council against Pace, and the plaintiff's land had been inundated by flooding. Therefore, the requirement that it should have acted in good faith was not made out. However, in a majority decision of the High Court, in the case of Punterino, it was held that the exemption did not operate to excuse all positive acts of a corporation. Now, the crux of what is being discussed here can be found midway through paragraph 3.43. Climate change will raise the same sort of problems and potential for legal liabilities. Policymakers have a choice. Either excuse the negligence of statutory authorities where they may need to experiment and thus force parties who suffer harm to bear the loss, or recognise the entitlements of affected parties to claim compensation, if not through the courts, through a statutory constructed compensation scheme. So there's the key. Environmental law will require certain things to be done. There will be, to some degree, some give and take. There will be, to some degree, some experimentation. What happens when authorities take action purporting to assist the environment in circumstances where their actions cause loss or damage to landowners? Will the government choose to simply exempt statutory authorities, excuse them entirely, and deprive the landowner of any compensation? Or will they allow compensation through the courts? Or will they allow compensation through compensation schemes? So 3.43 is an important paragraph. Over the page, there is an example given, that is Port Stephens Shire Council in Booth. They're a local council misled purchasers of land about noise impacts in a resort close to the RAF base. They were not allowed to rely on the exemption contained in the EPA Act for advice provided in good faith. There was a systematic failure due to inadequate control practices, and the council could therefore not rely on that defence. Another case is Melaleuca Estate in Port Stephens Council, where the New South Wales Court of Appeal said that where they had created the affairs that resulted in the nuisance, that is the council, through discharge of drainage onto the land, then the council's failure to remedy because of budgetary constraints could not readily be justified on good faith grounds. Statutory schemes, 3.47. Another approach is to create a form of statutory liability for nuisance and negligence, and thereby capture all the elements of liability within a statutory scheme, and that would displace common law principles of liability. So we have this coming up often. I'll give you an example of where statutory schemes have applied in a different area. It's to do with criminal compensation for loss. Victims of crime had typically had the right to sue for common law damages. The problem for the government is that the government would often pick up the tab for those through an ex gratia payment scheme. The government effectively displaced those former systems with a system which entitled applicants to apply in a very limited form for compensation through the statutory scheme. And that's what's really being referred to there in 3.47. My personal view is that we will see a progressive erosion of common law rights through the introduction of statutes which will direct people, rather than through the courts, to a statutory scheme administrative through the executive. But that's only my personal opinion. Now I'd like to go to 3.54. Landowners and others with rights to exploit natural resources frequently attract protest action. That is a right of peaceful protest, and that's regarded as a fundamental freedom. And there's the example there of the Franklin blockade in Tasmania, where 1,100 people were arrested. Legal issues surrounding direct activism frequently turn on whether the protesters have committed criminal offences. But if prosecution is made out, the penalties tend to be very low, and pursuit of costs in prosecutions is more likely to be a greater deterrent. At 3.55, industries at risk of protest action have turned their attention to civil claims for damages, threatening actions ranging from economic loss to defamation. And it's the purpose of those actions is undoubtedly to cause stress to those being sued so that they will take no further part in protest actions and to act as a deterrent to others. A successful legal outcome appears to be secondary. These actions are described as SLAP suits, strategic litigation against public participation. At 3.56, the most well-known example of legal actions being taken against protesters is probably the Guns 20 litigation instigated by Guns in 2004 against 20 organisations and individuals. That included Senator Bob Brown and the Wilderness Society against their protests and their campaign against old growth wood chipping in Tasmania. The litigation seems to have had as its main purpose an intention to tie up the respondents in lengthy and costly litigation with consequent threats against their financial resources. Common law remedies. Plaintiffs generally seek damages to prevent continuation or an injunction to restrain future conduct. All right. Before I move on, are there any comments or questions? I hope that's given you some overview of common law and the environment. I'll move on now to Chapter 8, but I'll commence with the introduction to Part C, which is at page 259. This part deals with environmental assessment, strategic and project-based. Arguably, says Bates, the most important environmental legislation in each jurisdiction is that which governs environmental planning and development. He talks about the sheer number of proposals for development on a day-to-day basis, having the potential to expose not only the local environments but also species of biodiversity to the realities of a death by 1,000 cuts, that is, the cumulative effects of sequential poor decision making. So for that reason, says Bates, strategic environmental planning is vital to identify the parameters for which the development may occur. Then, at the project-specific stage, a rigorous environmental assessment process is necessary to identify potential significant impacts. The point really being made there is this, that one can consider from a planning perspective at a local government level what appropriate conditions might be imposed for that particular development. But is that truly taking into environmental law appropriately when one considers that there is not just the one application but many tens, maybe hundreds of applications? And how is the government addressing the cumulative effect of those various conditions which are imposed not just for one but for many types of divisions? So we'll start in Chapter 8 with strategic environmental planning.
Excuse me, John.
Yes.
Talking about that planning issue,
yes, Tom.
Since the 2000 sort of 10-11 floods, there's a lot of areas in Brisbane, Mackay, for example, where they knew, or it was quite common that they knew that those areas flooded, and there was a high affected area, particularly Mackay, of a couple of hundred homes, where locals just wouldn't build there. Yet the council approved the development, knowing that they're in a flood zone. So I think a lot of that's going to be challenged over the next sort of few years, I would think, with people starting to get together with some sort of class action and stuff to try to get recompense for it.
Yes, absolutely. And that goes back to that principles of common law that we talked about as well, where the council may be exposed from that perspective also.
Yep.
Right. Thanks, Don. All right. So in Chapter 8, Bates opens with a comment that planning is the antithesis of chaos. The common law had no concept of public planning. Private landowners could effectively plan in a limited way by using restrictive covenants. A restrictive covenant is, for example, where a developer says that if you wish to buy one of my lots in this subdivision, you are under a restrictive covenant which requires you to build a certain type of house with a minimum size and facades that are consented to by us, etc. The alternative to strategic planning is totally ad hoc decision making. And planning is introduced to provide some order and certainty and security. And planning stresses the need to introduce order and avoid overexploitation by managing in a sustainable manner. For example, under the Sustainable Planning Act, Section 3. At 8.3, strategic planning describes the preparation of plans and policies at state, regional and local levels. And 8.5, one theory of strategic planning is that if impacts on resources are considered and accounted for at the outset, then subsequent developments need less rigorous evaluation, as might otherwise be required. In New South Wales, they have a biodiversity certification process. Now, that's further discussed in Chapter 12. That's not part of this course officially, but I will be making comments on it. In fact, I already have. That's to do with native vegetation. Development controls and procedures for assessment of environmental impacts are dealt with in Chapter 9. Environmental impact assessment in Chapter 10, which will be next week, and management of natural resources considered in Chapter 14. Part 2 of Chapter 8 deals with allocating Crown land and resources. And at 8.6, the Crown has taken control of and manages not only the resources of the Crown or public land, but also certain natural resources that occur on or under or pass through private properties, such as minerals, petroleum, and geothermal energy, water, sea fisheries, which occur in common or sovereign areas. Over the page, under the heading of Crown Land at 8.9, Bates says, in the past, economic exploitation of Crown land was always considered desirable. Today, the development and exploitation of resource is no longer an automatic or unquestionable process. It is as permissible to argue for the preservation of the environment in a natural state as it is to press for development. Increasing knowledge about the interrelationship of the ecosystems and biodiversity testify to a growing need to conserve aesthetically, biologically, and culturally important features. So in that paragraph, in 8.9, we really see how it's almost as if we have two icebergs converging now. We have the common law, which had simply not been fettered by environmental law, now being confronted by an opposing iceberg, if I can use that analogy, in environmental law. And the boundaries and the rules are being assessed and developed as we proceed. 8.13. Once the use of public lands have been determined, management plans may be drawn up to facilitate that use and avoid detrimental environmental impacts. At 8.15, environmental management of natural resources is commonly undertaken through the production of environmental management plans. Bates then goes on to talk about environmental and resource management plans in Part 3 of the chapter, commencing at 8.16, where he says environmental or resource management plans are required by legislation for the environmental management of most natural resources that are vested in government regulators. Plans may be broadly divided into strategic plans for management of a resource and plans imposed on specific projects. Over the page, plans must comply with objective legal standards for decision making, particularly relevance and reasonableness. And that's covered more in Chapter 20. 8.17, management plans must reflect and accord with the objects of legislation under which they're prepared. In Queensland, management plans for reserve must be consistent with the management principles specified in a particular class of reserve, and that's referred to in the Nature Conservation Act, Section 117. I'll move on to the fourth part of the chapter, which is Codes for Practice and Guidelines. That's at 8.25. Codes of practice may contain elements of strategic planning as well as practical guidance on how to conduct permitted activities. Over the page, the Queensland Planning Provisions of 2009 make provision for a statutory suite of overlay schemes. So in Queensland, various councils can either choose to adopt the Queensland Planning Provisions, the statutory suite of schemes, or undertake their own schemes as they see fit. Part 5 deals with resource management. That's at 8.26. Agreements for the management of natural resources may be made between governments, between different agencies of governments or between governments and private landowners. And that's dealt with in Part 6.46 of Bates. Property agreements. At 8.29, such agreements may bind the land that is burdened with the agreement, thus binding future owners to the content of the agreement. Now that's a little bit like the easement analogy I gave before, where if a landowner does grant a formal proprietary interest by way of easement to an adjoining landowner, that easement, the burden of that easement will carry on with the land, irrespective of who owns the land. And it's the same with property agreements, where it will be binding and burden the owner of the land. That makes for a conveyancing nightmare for people that are associated with conveyancing, having to determine the existence of and extent of a property agreement which burdens the land. Now, Part 6 of this chapter deals with environmental planning, commences at 8.30. Yes, Don?
Just on that planning, I struck a property not far from where I live, where it had been sold under the new government that had been bought up by the old Labor government for the Traveston Dam. And one of the properties was sold off in 6 sections, which left the centre, basically the centre main property with the house on it, no effective road to that property because the other 6 made up that. So how do they go about being able to sell a property with no access to it? Effective.
As I recall, under the Property Law Act, there is an entitlement to make an application to a court to seek appropriate access to the roads. But the difficulty there is determining necessarily which landowner should be attacked by such an action, because it may not be the case that there is one access only. Oh, that's a terrible situation.
Yeah, picture 7 blocks, and the 7th block is in the middle, surrounded by 6. So, yeah, where would the bloke go? And I just couldn't understand how they were allowed that the sale to go through under the conveyancing when the people weren't aware of it until they went to go to the property.
It's a bit like those blocks of land on Russell Island that were underwater. You just wonder how that could possibly happen. So, yeah, assuming that there are no easements in place to protect the interests of that landowner that was landlocked, the remedy would be, as I recall, under the Property Law Act.
Yeah, okay.
Messy.
Yeah.
All right. Now, Part 6 of this chapter deals with environmental planning. That's at 8.30. The framework for land use for environmental planning is the most important general means of managing the environmental impacts of development, particularly at a state or local strategic level, because planning controls cut across all aspects of environmental management. So we're really talking here about the framework for land use is the most important general means of managing environmental impacts. So what we're really saying there is at a local level, at the planning level, that's where a lot of this work can be done. It's also the framework within which members of the public often get their best chance to influence strategic planning through the complaints or objective proceedings. Environmental planning instruments is dealt with at 8.35, and the object of the strategic environmental planning are delivered through creation of environmental planning instruments. Now, the Sustainable Planning Act of 2009 deals with these issues and says, where a function or power is conferred upon an entity, the entity is instructed to perform the function or exercise the power in a way that advances the purposes of the Act, which is Section 4. And that might include ensuring decision-making processes apply, amongst other things, the precautionary principle. Now, you might have picked up that I tend to stop whenever I mention the precautionary principle, and that might be construed as an exam hint. At 8.38, generally speaking, strategic planning takes on 3 different levels: state, regional and local. And at 8.40, states may attach a greater or lesser degree of legal status to environmental planning instruments. In Queensland, a state planning policy is a legal instrument that has effect throughout the state unless the policy states otherwise. And that's sections 41 and 42 of the Sustainable Planning Act. At 8.42, environmental planning instruments commonly seek to achieve their objectives by introducing requirements for development consent for projects and activities, by prohibiting certain types of development, by requiring environmental impact assessment for certain categories of development. We'll deal with that next week. And by requiring ministerial concurrence in relation to specified projects and activities. Inconsistencies between instruments is generally dealt with according to priority. State plans and policies have priority over local plans. Then Bates goes on to describe state and regional environmental planning. And at 8.44 says the advantage of a state or regional plan is that implementation of the government's objectives is not then left to the discretion of individual planning authorities, which might vary in their commitment. So statewide or regional planning enables the government to coordinate a response for a particular matter of environmental concern and require a uniform and consistent approach from state and local government, applying common standards throughout the state. Now, I think that's really important because that goes to the heart of the comments that were made by Bates in the introduction to this section, where, as you will recall, he talked about or something like death by 1,000 cuts. So by having the coordinated approach adopted through the state and regional planning instruments, the local authorities hopefully will be in a better position to ensure a consistency of approach in terms of individual planning issues. It then goes on to describe at the next level down local environmental planning through 8.48 and beyond. The only thing I'll comment there is in relation to 8.52, dealing with existing uses. The introduction of local planning scheme does not automatically mean that all non-conforming uses of land within the area covered by the scheme have to cease or close down. Existing non-conforming uses are generally allowed to continue by legislation until they determine naturally or they're abandoned. Environmental consideration in land use planning, 8.56. In Queensland, key elements of regional planning schemes are that they should, amongst other things, identify the environmental, economic and cultural resources to be preserved, maintained or developed, and that's section 28 of the Act. Now the seventh part of this chapter, integrated strategic planning, commences at 8.62. Integrated strategic planning that combines traditional environmental planning with natural resource management is developing from the recognition that dividing natural resources and environmental values fails to recognise the reality that the environment is an integrated unit where different facets make up the whole, depending upon each other. So this is integrated strategic planning. And you'll recall that our legislation in Queensland, the Strategic Planning Act, was the replacement act to the Integrated Planning Act. So these issues are important at that level. At 8.72, Bates says, one of the criticisms of environmental assessment procedures that centre on evaluation of particular developments or activities, or even more strategic or forward planning processes, is that the cumulative impact of decision-making on natural resources is frequently overlooked. And I'll just round off the chapter by referring to the eighth topic, which is on page 294, strategic planning and project control. One of the primary purposes of strategic environmental planning is to set the parameters for future development control and resource allocation. Development control is dealt with in chapter 9, which we'll deal with now. Environmental impact for next week is in chapter 10, and then there's pollution controls and waste management, chapter 15. So we'll now move on to chapter 9, which won't take us too long. Are there any questions in relation to that issue of strategic environmental planning? The way in which the governments work at different levels, the introduction through legislation of information and controls at a state level, going down to the local level.
Yeah,
Yes,
g'day,
Rob.
John. It's Rodney here. It sounds like the Pettyjohn case at the end with the Far North Queensland regional plan thing. It sounds like it, in the end, overtook everything else that he wanted to do anyway, and so changed the whole issue of the whole piece of land that he was looking at. It looks like one of those issues because I had questions, but they're all gone. I'm just not thinking clearly at the moment.
All right. Thanks, Rodney. And there's also the chat facility too. You can ask a question through that if you wish.
Yeah.
All right, let's move on to Chapter 9. As I said, it won't take too long. Environmental Assessment of Projects, Development Controls. 9.1, Government and local licensing of projects that are likely to have environmental impact is the cornerstone of environmental management, that is at that executive level. This chapter is about assessing the environmental impacts of development. The objectives set out in the instruments provide the ground rules, and the objectives of environmental management plans constrain the exploitation and use of natural resources. Now, the first part, development control in legislation. Over the page, it's generally an offence to carry out development without consent where consent is required. State environmental planning instruments provide guidance and do not create inflexible regimes of control. Where a local environmental plan is required or requires that a development consent be consistent with the objectives of the plan, that does not require a positive finding of compatibility. Rather, it's meant to be not incompatible or inconsistent. So I think we talked about this before. Planning law in Queensland has been revamped so that it's far less prescriptive and it provides general guidelines. And generally speaking, a plan is not necessarily doomed to fail, or a project is not necessarily doomed to fail simply because it fails to comply. It may well still be eligible in a general sense. To elaborate on that, at 9.5, under the relevant planning scheme, development may be classified as permitted, development that does not need consent or exempt, complying development, prohibited development, or development that needs consent. In Queensland, all development is exempt unless falling into a category that requires assessment. Before development can proceed, applications need to be referred to government agencies, either for concurrence with the development proposal or for advice in relation to it. Many proposals for development will also require the issue of licenses. For example, in addition to development consent, the proposal may require separate licenses to clear native vegetation or emit pollution or deal with impacts on heritage areas, for example. So effectively, other licensing agencies may therefore be able to veto a proposal by refusing to issue a license for aspects of the proposal controlled by them. So I hope you're all familiar with the term concurrence and concurrence agencies. So it was previously the case that applications were considered by the council, and that was pretty much it. But now, in the new regime, concurrence agencies have input, either to make a decision, which is effectively a veto decision if they wish it to be, or to provide advice. At 9.8, just because a development does not need planning consent does not mean, however, that environmental assessment will not be relevant. And at 9.9, if the proposal is one in which the permitting authority does have power to refuse, the authority will generally be required to advertise the application, and then after due consideration, any public submissions prompted by the advertisement are considered, make a decision whether to permit the development or refuse it. Over the page, apart from such rights granted by legislation, the general proposition is there are no rights to public notification of a development unless the instrument extends such rights although many authorities do make a practice of giving informal notice to adjoining landowners or relevant stakeholders. And that's all to do with the rules relating to natural justice. Failure to comply with public notice may result in the process being declared legally invalid. And an example of that is Skur against Brisbane City Council. Now, the second part is assessment of environmental impacts of development. In making a decision about an application for development consent, environmental factors are of prime concern. And at 9.11, proposals that are likely to involve significant environmental effects may be required to undergo a formal process of environmental impact assessment, which is in Chapter 10. Now, for the Queensland position, we'll go forward to page 313, where in Queensland, and this is at 9.31, all development is exempt development unless it is accessible, self-assessable or prohibited, or development requiring compliance assessment. And then we talk about the IDAS system, the Integrated Development Assessment System, where IDAS integrates decision-making for development approvals under the Sustainable Planning Act with decision-making for activities under other laws. IDAS has several stages. They're described over the page: the application stage, the information and referral stage, the notification stage, the decision stage, and the compliance stage. But not each one of those stages will apply for every development assessment. I'll just make a few comments now. Assessable development at 9.33. A regulation may require impact or code assessment, or both impact and code assessment for assessable development. Code assessment means the assessment of development by an assessment manager against relevant instruments, whereas impact assessment means the assessment of the effects of the proposed development. Now, what you'll find is that at a council level, various projects, various proposed developments will be either categorised as impact or code assessable. And in short, different rules apply for the assessment depending on whether they're code or impact assessable. I'll move ahead to planning agreements at 9.47. A planning agreement is a voluntary agreement concluded between a developer and a consent authority, under which the developer may agree to provide material public benefits or pay compensation for public purposes, or otherwise achieve or advance the purposes of a planning scheme. Part 4 of this section is fast-tracking major projects, 9.52. Fast Track is a device to provide a streamlined approval process for developments of particular economic or other significance for the state. In Queensland, under the State Development and Public Works Organisation Act of 71, significant development may be fast-tracked by having all relevant permit applications referred to the Coordinator General for environmental coordination. And at 9.54, the Queensland Government's assessment of the importance of the tourism industry to Queensland economy led to the passage of the Integrated Resort Development Act of 1987 to provide an accelerated government approval for large-scale private tourist development proposals. At 9.60, in Queensland, in addition to the powers of the Coordinator General referred to above, the Minister may give directions to assessment managers about matters of state interest or call in a development that affects the state interest, so that the Minister then becomes the consent authority. At 9.64, another way for governments to facilitate major development approvals or projects is by persuading Parliament to enact special legislation, and many long-term developments have been approved by that process. Such techniques are generally used to support multi-$100 million minerals recovery and processing projects. For example, the Mount Isa Mines Limited Agreement Act of 1985, so a special Act just for that purpose. Now, 9.69 deals with appeals, where applicants for development consent or objectors to development applications are often allowed to appeal the decisions of planning authorities to specialist courts or tribunals. Since these are merits appeals, the decision of the appeal body on the merits of the application is final, although points of law may then be the subject of referral to another court. Just the final comment for tonight at 9.72. Significant examples of merits appeals are reported in publications such as the Queensland Environment and Planning Reports, QEPR. All right, thank you very much for your patience. We covered a lot tonight. Are there any questions? All right. Yes, Don?
No, that's all right. It's all good.
Okay, thank you. Well, for those of you who haven't submitted your assignment, all the best. For those of you who have, thank you very much. And next week, next Tuesday, we'll be dealing with Chapter 10, Environmental Impact Assessments, both at a federal and state level. And hopefully we'll have a guest speaker. All right, so thank you very much for your attendance, and please shoot through any emails if you have any questions.